Hello friends, in the series on the income tax cases, today we will discuss a very important case on the Benami transactions. The name of the case is MARG Realities Limited versus Deputy Commissioner of Income Tax. This case has been reported in 448 ITR at page number 574 and the date of the judgment is 25th October 2021. In this case, under section 24, the initiating officer issued notice to the assessee by causing him that why he should not be treated as Benamidar and why the transactions entered into by the assessee should not be treated as Benami transactions. The initiating officer was not convinced with the submissions of the assessee. The assessee was saying that the property transaction has not been completed, the consideration is yet to be paid in full. So these proceedings should not be initiated against me at this stage. But the assessing officer was not convinced and he also provisionally attached the property of the assessee. Under section 24, there is a provision that the initiating officer can attach the property provisionally for 90 days and then he can also enhance this period by taking approval from the approving authority. When this period was enhanced by the initiating officer, the assessee went into the writ court challenging the enhancement of the period of the provisional attachment. The main apprehension of the assessee was that the property transaction has not been completed, the consideration is yet to be paid in full. I have not been supplied the full material on which the initiating officer was relying. The assessee said that I have not been provided the opportunity of cross-examine the parties on whose statement the assessee was, on whose statement the initiating officer was relying. When the court heard the matter, it was the opinion of the court that under section 24 subsection 1, if the initiating officer has the information in hand, then at this stage he is not bound to give the opportunity to the assessee for cross-examination at this stage, or the material should not be supplied at this stage. When the assessee will be before the adjudicating authority, all these contentions can be raised before the adjudicating authority, but at the investigation level the assessee is not entitled for the documents for the cross-examination. And it was the point of the court that since in this case the assessee has not cooperated full, or the assessee was not able to demonstrate before the initiating officer that the transactions were not Benami, so the writ of the assessee cannot be allowed in this particular case. The assessee was challenging the reasons to believe for initiating the proceedings under section 24 subsection 1. For this, the court said that if the initiating officer has the primary reasons to initiate the proceedings, then the court is not there to challenge the sufficiency of the reasons. If the reasons are there, if some material is there, then it is more than sufficient to initiate the proceedings under section 24. So the court said that the assessee is well within its rights to claim all these things, that is the opportunity of cross-examination or the point that the full consideration has not been paid before the appellate authority under section 26. So in this particular case, the court declined the writ of the assessee. My opinion on this judgment is that with due respect to the Madras High Court, the provisions of the Benami Act are very harsh. They give the plenary power to the initiating officer. The initiating officer is not of a very high rank, but he has the power to attach the property of the assessee by taking the approval from the approving authority. We all know that how the approvals in the income tax are given. They are more or less mechanical. The approvals are given only in the form of yes, I am satisfied. No comments are added whenever the approvals are given. So if the approvals for attaching the property and the property of the assessee will be attached in such a way, then there will be a very chaos in the judicial system or in the chaos of the fiscal system, because the confidence of the assessee is losing nowadays because of the multiplicity of the proceedings, whether it is going under the Income Tax Act, Benami, Prevention of Money Laundering Act or Black Money Act. There are a number of the acts and the proceedings under the different acts are different. So in this type of cases, because the tribunals are not separate, the system is not well within its reach, there are very less number of tribunals, because for the Benami Act also the tribunal in which the assessee has to go or the department has to go is the same. So in Benami Act is a very harsh act, and the provisions of section 24 are very harsh as far as when the attachment of the property is concerned provisionally and the enhancement of the period of the provisional attachment. At the end of this video, once again I am repeating the name of the case. The name of the case is MARG Realities Limited versus Deputy Commissioner of Income Tax. Thank you, friends.